when you spend, it means there's something you are buying. Even if you're paying a debt, you're buying peace of mind. You're always buying something. What I&M is saying that, look, we have come up with something we are calling the World Credit MasterCard. And this MasterCard doesn't just offer you the services of a credit or a debit card. It goes further. Every time you spend money, you swipe it, you also earn points. It's like a portion of what you spend comes back to you. If you accumulate it to a certain degree, you'll be able to do the same things you're doing with a card. You'll be able to buy stuff, pay for stuff. That is what you'll be able to do. And they're saying this: if you happen to be the individual who is the 20th to register, then you stand a chance of winning 50,000 shillings. Now, the 50,000 shillings comes in points. And the points are called milele points. So 1 milele point is equal to 1 shilling. So 50,000 milele points is equal to
50,000 shillings.
So that is points you can do what again with?
Shop and win. And fly.
Yes, you can actually spend. Now, how do you get this? Well, you have to go to the I&M on the Go platform. That is where you get to register.
Good stuff. A place where you go, you register, and then you start to earn and
Get the card, start using the card, start earning the milele points.
Fantastic.
Yes.
All right. That is justice, if you ask me. It's a Justice Thursday conversation that we're getting into this morning, and both of our guests are in the studio. We're talking this morning with the Honourable Evelyn Olwande, who is a Chief Magistrate at the Milimai Family Court, as well as a Commissioner at the Judicial Service Commission. And we're also speaking with Honourable Festus Terer, who is a Senior Resident Magistrate. Good morning to you both.
Good morning.
Good morning.
Karibu Sana, and welcome to the hot seats of the Situation Room, Justice Thursday conversations, whereby we still unpack a lot of the issues. And it's good that we're having a conversation in family court today, essentially, because a lot of questions, a lot of issues coming out of these courts, but then just to understand a little bit more about how you break those things down. Before we get into it, as is our tradition, CT has a proverb from a different African country every week. He'll tell you where we are this week, and then, as you often do, we would ask you to then interpret what this particular proverb means. Is that all right? Okay.
We'll try.
All right.
We'll try.
This country has a population of 888,000 people. It's an archipelago. It's an extensive collection of islands. And it is in the Indian Ocean. Now, in Kenya, we have something similar. In the county of Lamu, Lamu is actually an archipelago. If you take Manda, go to Siu, go to Pate, go to Shela.
Kipungani.
Exactly. That's Lamu. Now, the beauty is that it's within our country. Within the county of Lamu, it's within the country. Comoros is just those series of islands that form this particular union that you call the Comoros. It was once a French colony. There's an island not far from it called Mayotte. The Comorans claim it, but the French believe it is still their territory. The capital of this particular country is called Moroni. Moroni, by the way, I keep repeating, it is not Muhoroni, where I come from. It is Moroni, okay? Lest somebody thinks CT has decided that he's going to talk about
His place.
No, it's called Moroni. The proverb: the thread follows the path of the needle.
We can start with you, Honourable Olwande.
The thread follows the path of the needle.
Yes.
I think what I would say is that essentially it means something would follow whatever leads that thing, or a person would follow the leader. If your path is already laid, then you automatically follow that path.
Okay. Now it's your turn to adjudicate.
I would interpret it this way that
Yes.
and I would look at it in a family context. that a child will always follow the directions of a parent. That's how I look at it.
Do the needle and thread have any relationship? If I'm to follow from what you just said.
Obviously, they have.
They do.
Yeah.
Because one cannot function without
the other.
Okay.
And the needle will often lead the thread. But the thread will take the direction that the needle gives.
Exactly.
Yeah. People will take the direction that their leader gives.
Exactly.
Okay. You're both right.
Oh, thank you.
I love the way she said, "Oh, thank you." She was on tenterhooks. Are we in the right direction?
No. The thing about your own interpretation, it is your own. It's how you resonate with the proverb, and so you can't be wrong.
True.
Yes.
Indeed. Thank you both for being here this morning. As we do with our Justice Thursdays conversations, what we try to do is then open up about certain things which would appear amorphous or vague or, not in common understanding with a lot of people in terms of what happens. We're looking into the family courts today, of course, and increasing access to justice. And in family court today, we want to start off with understanding what happens in family court, who comes to family court, who then would bring the issues, and what kind of issues are addressed in family court before we start to get into the nitty-gritty. And we can start with both of you on that. We'll start with you, Honorable Olwande.
Thank you. The family court essentially is the court where family disputes are resolved. And the family court has jurisdiction to handle cases that deal with succession of properties, that is inheritance of properties of persons who are deceased, be they testate or intestate. The family court also deals with situations where marital relations have broken down and now parties require or desire dissolution of the marital union. The family court also deals with cases involving domestic violence, so protection against domestic violence. And the family court also deals with matrimonial property. So often after dissolution of marriage, then now we come to the issue of how the property that was jointly acquired is supposed to be distributed between the parties to that marriage. So essentially those are the matters that the family court deals with, the court that we are in. And we do not deal with matters concerning children, maintenance, custody of children, because there's a specialized court.
The children's court for that.
The children's court that deals with that. Yes, thank you.
But then we do have offshoots that matters could have begun in the family court and then would then be referred to the children's court?
True, more often than not, and then maybe just I add one other item is that we also deal with issues with burial disputes. If we lose our lovely one, our dear ones, and families don't agree on where the bodies would be interred, then they knock our doors. Yes, and then more often than not, family disputes originate from family, but for us we only deal with the ones which we've set out. But invariably, most of these disputes touch both the adults in the family and also children. But for purposes of good order, the judiciary has made it sure that issues to do with children are dealt with separately in the children's court.
All right. As we look at then increasing or enhancing access to justice, particularly in this court, what had previously been confusing that people didn't understand they could actually bring to court? A lot of matters, we sit at home with them and we, duke it out. But how did we start to see that people now come to court and these matters are actually then taken care of? What would you say then was that thing that broke it, where people say, actually, you know what, instead of us sitting here, we can actually bring it to court and then there are folks who can actually help?
Okay, traditionally, what we have been doing is that matters concerning families have been dealt with together with other cases, the other general cases that usually come to court. There has not been, especially in the magistrates' court, a court that specifically deals with family disputes. So what I would say has changed is the creation of a specific court that deals with issues concerning family, so that their issues are given primary and sharp focus. And in answering that question, also we would look at what are the impediments to access to justice. What has been making it difficult?
Yeah.
One of the impediments is the high cost of litigation. So a lot of the court fees in the family court has been subsidized so that it makes it easier for litigants to be able to access the services of the court.
Yeah.
The other deterrent factor is the delays. It takes very long to dissolve cases in our courts, on average about 2 years or so. And one would be discouraged. If you imagine that you have a dispute here that will take so long to resolve, you may even decide to look for other means of resolving your dispute.
Yes. Yeah.
But now, because we have a specialized court dealing with family matters, then those cases are now expedited. So we are dealing with that issue of delay. And then, still on the subject of delay, we've also introduced which has been introduced for the judiciary as a whole, but is also effective in the family court, the concept of mahakama popote. So that we are able to distribute cases evenly or equitably across the Republic. Traditionally, what we have been doing is that if a case is filed in Mombasa, the magistrate in Mombasa will deal with it, regardless of how many there are. So you may find the magistrate in Mombasa is overwhelmed with maybe 1,000 cases or 2,000 cases, while there's another magistrate in a town like, let me use the town where I come from, Madiang Law Courts, in Siaya, Rarieda district. They don't have much work. So by 11, the magistrate sitting there is done. So we through automation, we've made it possible for the magistrate in Madian to help with the workload in Mombasa, for example.
Okay.
That has improved access to justice. Also to expedite the automation of the court system, as well as the introduction of the virtual courts has really improved access to justice. Because now, regardless of where you are able to access court services. You need not travel. That also has an impact on cost, of course. You need not travel to where the court is to be able to ventilate your case. You can log into a courtroom, even from your living room, and be able to access justice. The other challenge, of course, has been the lack of awareness. Most people may not even be aware that the issues they are facing are issues that can be resolved in court. And so what we have been doing is to try to sensitize members of the public or the litigants that would be on the services that the court offers. And that brings me to what we have now organized, which we're calling the Family Open Day, that is supposed to be held tomorrow at Milimani Commercial. So during that session, we are going to have an engagement with the public, basically to sensitize them what we deal with, what to expect when they come to court, what is required of them when they come to court. So that way, we are hoping to enhance access to justice. Yes, thank you.
Yeah, so when we talk about, Mheshimiwa, you had spoken to matters to do with issues to do with burial issues that would come up, and one would also look at it in terms of these are just issues that you can just finish as a family. So is ADR as well one of the solutions that one would approach with the help of the court?
Thank you so much. ADR is one of the instruments we really advocate and has really helped the court to really ease case backlog. Now, in the family court, we are one of those courts where we really utilize the services of ADR. And by ADR, in this context, is that we're talking about court annex mediation.
Yes.
So more often than not, when disputes knock on our doors, especially burial disputes, we really encourage parties and really encourage parties to resolve the disputes through mediation. And in our case, we have court annex mediation, which is within the context of the court, and more often than not, cases are resolved.
Would you say that more Kenyans are getting onto ADR as an alternative? Because then again, there is the issue of backlog cases and the time taken. So in terms of Kenyans approaching ADR as a faster mechanism to handle disputes, would you say Kenyans are embracing it more?
Now, I can still pick it up. In court annex mediation, and this is where now we are really doing a lot of awareness, is that this is a system where the judiciary has put in place to resolve cases through ADR within its parameters, so that what we do is that we have a list of mediators within our system where people can choose. How do we refer cases to mediation? Cases are filed, we screen them. We screen cases, send to mediation. I could be having a case which is coming in my court list. I see this one is suits to be sent to mediation. We refer it. Now there is the concept which we are now really advocating at the moment. It is the concept of private mediation. What does it mean? It means that even before a case knocks in the doors of justice, that is judiciary, parties can still appoint a mediator within their auspices, have that mediator resolve a dispute, come up with a settlement, and then knock the doors of justice, knock the doors of our courts by way of registering that settlement. And the moment it's registered, it becomes an order of the court, enforceable.
What do we see that continue to pose as challenges towards the cases that people bring to the family court? And I want to now start to focus on some of the things that grab public attention or that even grab public involvement. And a lot of that is one of the things that you mentioned, and Honorable Olwande, in the case of dissolution of marriage, divorce, separation, and things like that. What would you see as some of the challenges, before I tell you what some people are saying are some of the challenges that they see?
The challenges that to access to justice?
When it comes to these issues of the dissolution of marriage, divorce, and getting to that point whereby, folks say, it is enough, we cannot go beyond this, we need to actually get a dissolution. And do they actually bring these cases to court? And by the time that they do, I know one of the things that you mentioned is the time that it takes for some of these things then to be processed. But what are some of the things that you see would be challenges to these processes, apart from the time that it takes?
Okay, the challenges that people face that make them eventually decide to come to court to seek dissolution are varied. There are many. The law recognizes several grounds for dissolution of marriage. We have the ground of cruelty. One spouse has been cruel to the other, or has been cruel to the other. Or we also have the ground of adultery. One spouse has committed adultery against the other. We also have the ground of desertion, where one spouse simply just walks out of the marriage and the matrimonial home and stays away for a minimum of about 3 years. We also have the irretrievable breakdown of marriage, where the parties simply cannot continue to live within the union of marriage. The reasons may be many. And some of the challenges, maybe I can say, that parties experience, as I've already mentioned, there's the high cost.
Yes.
Then there is also the time taken, and then there's also the element of stigma. I imagine some people feel that a failed marriage means the person has failed. Failure. And we conduct our proceedings with the confidentiality that is required of the situation, so that you do not have to expose a lot to the public what exactly is happening in a particular case or a particular situation the party finds themselves in. And I think also the law has really grown to some extent, so that unlike in the past where the process was so, let me say, grueling in terms of what you needed to bring out before the court can be persuaded to allow you to dissolve, or persuaded to dissolve your marriage, we have that ground of irretrievable breakdown where we can look at many other factors. It doesn't, and you don't really have to go out of your way to paint the other as a demon for you to be able to get dissolution of marriage. Yeah. So at least that way, whatever relationship is left that you need to maintain even subsequent to the dissolution of the marriage is somehow still preserved, because there are still other parties. Sometimes you have other parties to this marriage that you cannot let me say disconnect from, for example, the children.
Yes.
So I know there's that stigma that bothers other people. Of course, there's the high cost, and then which we have tried to address. There's also the issue of delays, which now at least the family court has come to address. maybe I should say here now, at the risk of being accused of blowing our own trumpet, is we've introduced systems in that court to make sure that things move like clockwork. So that if all things remain constant and you file your case in January, like I'm aware right now, we are already hearing cases that were filed in January. So by around April or May, you should be able to have your divorce. Compared to the turnover time for most cases in the Republic, that is, I think, quite efficient and fast enough.
Okay. And is it taking this time because there are other cases, or are there things that are happening in the back end whereby information is being gathered, investigations are taking place to contribute to the court process? Or is it because there are other cases and that's why it takes so long? Because I would reckon that if two people come and they say, you know what, we're done with this thing, can we have it, dissolved just the way we came to court? You got the license to get married in the first place. I would imagine that you come and say, look, I've said it, I've also agreed, can we go ahead? So what would be the thing that would delay it? It would, from the naked eye, it would appear that, okay, if two people have come, it would take a day. Look, we don't want, we're not doing again. Can we? Yes. Do you? Yes.
Now, from where I see it, I'm not looking at divorce cases in the context in which we are tackling it now, because from where I sit as a family court, number one is that the number of those cases knocking at our doors are really numerous.
Really?
So that the question you should be asking ourselves is, what is really the trigger? What is happening in a society so that we have it? Like as we speak now, we normally do our series in terms of when we begin the year, we start with case number 1. As we speak, I think we're almost reaching 600 cases for divorce filed this year in the family court.
In 3 months?
Exactly. So the question should be, what is really the problem? And if you allow me, and based on the experience we've had, is that there are many things which have happened in the country as society evolve. And as we and as it were, that when we pass the new constitution, I think we put it in ourselves that we really need to recognize family in the constitution, and that's where Article 45 of the constitution comes in, where it says the family is the natural and fundamental unit of a society, and it's the basis of societal order, and that the government needs to recognize it. So that now the question is, what is really happening in the country so that we are having these numerous cases of divorce? From where I sit, I look at it this way. Number one is that when these people are coming together, whether through the church or through the customary or through any other mode, do we really induct them so well on what to expect in a marriage? Is it that we're just going to the marriage because of love? Because what we've seen is that 1 or 2 years down the line after getting married, the reality dawns.
That this is
For
not
a
your
man,
relative.
for a man, for a woman, the wife, kids come here. The reality dawns. It's no longer love. It's about responsibility. So that do we really even for marriages conducted to the church, do we really take these people through proper counseling so that they expect, so that they anticipate what is coming, what is ahead of them, especially in the context of social media?
You put it very well. I was going to ask the question, and now you've gone and answered it. Let's ask the question: do we find many cases going for ADR?
For dissolution of marriage?
Yes.
I can say minimum, and I can even put it in the maybe around 20%.
All right. The issues around family disputes, disagreements, misunderstandings, do we see many cases going for ADR?
The answer should be yes.
But it isn't.
It isn't, because, and I'll answer it this way. Most of the cases we receive is that we are dealing with cases where people have been separated for the last 3-4 years, and then the problem is not even about separation. By the time they come to us, more often than not, a lady or a man has moved on. What she wants is this document from the court so that they can validate the other union.
Yeah.
So that now those are the bottlenecks. So that when you try to tell them, why don't you try to go and sit down, they will tell you, what do you mean?
That ship has
My
sailed.
man is here. I'm supposed to formalize this wedding before the AG in the next 2-3 weeks, and you're telling me to go and discuss with my ex. How? It can't work. Those are the challenges we are facing.
You know, you hey.
Okay. Let's take a break. Let us take a break, because I think it is necessary for us to come back. Because I'm already hearing that when we talk about access to justice, it's as though we've seen it before, as the courts have said, we will deal with what has come to us, let's deal with it and go. But what I hear us saying now is that we also want to take on a preventative nature to some of these things, so that the court process is dealing with those things for which you don't have a choice completely, but to deal with from an adjudication point of view. So I'm hearing that the court is also taking on these issues as matters of health, whereby we'd rather prevent than cure. And so let's dig a little bit deeper into that when we come back from the break. The Honourables Olwande and Terera are here with us this morning, and we're looking at increasing or enhancing access to justice in the family courts this morning on our Justice Thursday conversation. It's 26 minutes to 8. We'll be back right after this to continue with this conversation.
Kila safari huanza na ndoto. Ndoto za kufanikiwa maishani. Ndoto za kufanikiwa kibiashara. Ndoto za kufanikiwa kimaendeleo. For 4 decades, we have been your trusted partner, witnessing the achievements of each generation. As we celebrate 40 years, our promise is to be with you for life. Tufanikishe zaidi.
This new year, discover something new every day on your StarTimes decoder. Buy an aerial decoder plus 1 month free classic bouquet subscription to enjoy the magic of African stories on ST Swahili, AMC Movies, and ST Nollywood. Tales of adventure that take you far on Bliss TV, ST Kung Fu, Z Cinema, and Nat Geo. Or a dish decoder plus 1 month free super bouquet subscription to watch heartwarming dramas that bring you closer.
Do you want to be my wife?
Yes, David. I want to marry you.
Exciting kids shows to keep the little ones entertained.
You got it, dude.
Experience the thrill of live sports on La Liga and Bundesliga. For every mood, for every moment. StarTimes. Enjoy digital life.
Well, hello, teacher. Look at my motorbike. It's very dirty. Wash my car. Sukapo. Kijana wake nini, President Museveni anaitwa nani?
General Mhozi.
You wanna stick to that answer? Hata huyo ni best yenu.
Hiyo hata nimemwachia.
Mwachia?
Na leo nipo katika shule ya msingi ya Milimani Star Junior katika eneo la Kiserian katika kaunti ya Kajiado. Shule hii ina somo la lugha ya ishara. Tutakuwa tunaangalia umuhimu wa somo hili.
Pale wanaishi wakipatana na mtu asiyesikia wanazungumza naye.
Si kitu ngumu kwangu.
Na tukaona baadhi ya matelevisheni huwa inaleta habari zake na kuna mtu ambaye pale anatafsiri kwa lugha ya ishara. Tukaona ni vizuri pia tuanzishe hapa kwa shule yetu.
Kwenye kipindi cha elimu.
This week on Culture Quest, you are coming live from Malaysia. Our focus is on the cultural diversity of the Malaysian community. And how palm oil is binding this fabric and taking the heritage to the international stage. Food is more than just substance. It tells the story of a people, a history, and a way of life. Today, we embark on a journey from Kenya to the heart of Malaysia. We will explore bustling food markets, meet passionate vendors, discovering the sizzling, aromatic, and mouth-watering world of Malaysian street food, and dive into flavors that have been passed down through generations. This is Culture Quest.
Go and explore possibility of reconciliation, especially where it has become apparent that that has not been tried. But in most cases, as my colleague has mentioned, by the time they are coming to court, they are done and dusted. They just seek the formal pronouncement from the court, because the law also provides that you are not divorced until a decree of the court has pronounced you as divorced.
But the question comes in that when you were coming together, that there was not much attention in terms of, well, nobody's asking you why you're coming together. Do you really, really love each other? Are you ready for the future? I mean, sure, there were things like counseling. If you got married in a religious setting, there were, we know that amongst the religions, they will ask you, like in church, they will ask you, they will announce it 3 times or however many times that they need to. In our Islamic culture as well, they will ask you if this is actually something that you want to do. You will go before elders. Across religions, that's done. But more or less, folks are going to believe that you people have decided that you want to come together. There's not much scrutiny in terms of you coming together. It seems that it's a lot more difficult to get out of the thing than there is to get into it.
That is true. That is true. And because, in fact, from the preamble of our constitution, we make that commitment to protect families. Yes, you freely come together, and someone would imagine we should also freely be allowed to just walk away if we choose to. But the implications of walking away as compared to the implications of you two coming together, the implications of walking away may affect very many other things. And if our society is to grow and to remain stable, really, the protection of the family is necessary. I appreciate there's been that debate about whether we should actually allow divorce by consent, so that you just walk to court and file a document and say we've agreed to parted ways and you go separately. But I also appreciate the arguments against that kind of proposal, because then if we made marriage so easy to walk into and walk out, then the scenario that our brother here had painted, Siti had painted, then what becomes of it? What becomes of society?
The question that also comes to mind as we're looking into this is, if we look at the cases that come to the courts and they're increasing in number, is there need for the judiciary to partner with psychosocial counseling entities? Because I believe when a court issues an order, the next step is for you to obey it, isn't it?
That is true.
Yes, so cases that clearly require a different approach, can mediation not be suggested? Even as you say, look, go and think about it, specific, and say you need to go and see such and such a person. They will give us a report, and based on that report, we'll proceed with the case. Is it something that is possible?
Maybe I can answer that question. It's something that, no, it's not even something that is possible, but it's something that we do. You remember when we started this conversation, we talked about court annexed mediation, and that under the rules, the court has powers, even without seeking the consensus of the parties, to refer the matter to mediation, whether you like it or not. So that we say, as a recourse of first instance, court mediation, a mediator will be appointed. Try to resolve this issue. If it doesn't work out, then come back to us. But the most important thing is that, as you say, it has reached a time now when all of us as stakeholders, we need to have these conversations and try and try to find ways of fixing the family. We can't fix the family as a court. That one I can assure you, because you see, for the court, my court is cut. It's clear. I just apply the rules. You want to divorce?
Yeah, go ahead.
Go ahead. But you see, are we doing justice to the family? We are not. So that and that's why we're having these conversations. Even tomorrow, we're having the open day, so that we open gates for all of us.
Sure.
Stakeholders address these issues.
That's interesting, because I think even as we have this conversation, then it's clear. And again, I think to make the ties that historically the judicial service, the courts, would appear to be just what you said. Okay, this is the fact that I'm dealing with. You've brought the facts as two different parties. You bring it here, we deal, we move. You want to dissolve, we dissolve. But to see that, I think there's a transition happening here where we're saying, you know what, then are we doing justice to the different parties that are involved? And we are actually then involved in the process of making sure that you can do the best, or you can do better than what you have. And I think that's a transition that we see when we talk about access to justice, that is actually taking place. Then becomes it seems as though we become more caring as a society, and it's not the bench looking down at the rest of us and saying, well, I have the facts and this is how I'm going to rule. That there is an element of protection, essentially, that is coming through today.
True. And then and what we have done, especially as the courts all over the country, is that we have one of the organs under the organs of the court, which we call it court users committee.
Yeah.
Now for our family court, we have really made it deliberate that in this committee, because we draw parties from different stakeholders, we've made sure that we have stakeholders, and especially the judge, representation from the judge, so that as we discuss these things and give them feedback on what's happening, it's cascaded back down to the church, the grassroots. So those are also the things we are pushing in our court.
You know why I brought in the discussion of psychosocial counseling? The mediation is excellent and it's needful. Psychosocial counseling goes into the issues that are not being spoken of, but are clearly the trigger. The mediator may be able to do well in understanding how to get both parties to come to a consensus. But the psychological training or the ability takes you further, much, much further, because it gets to dig into the person, the issues that they have, a whole load of things that one cannot in one sitting if you're trying to figure out the problems, because the problems are a manifestation of something else. I ask this because sometimes what the judiciary has done with the committee that they have formed is a sign that they know you need a well-rounded approach to these issues. But there's always room for more. In that committee of yours, do you have psychosocial counselors? Do you have psychologists?
That is maybe an area we need to think about. The composition of the court users committees is not necessarily fixed. And just to answer your question, here and now, we do not have representation from the practitioners in counseling and psychology. But yeah, I agree with you. It is an area we can explore and see maybe, if we can bring them on.
And maybe to chip in on that is that as you propose is that before I joined the family court, I joined last year in September. I sat in the children's court for over 5 years, Milimani Children's Court, and that the proposals you are making is that they are really valid, because in the year 2022 the Children's Act was amended, and that most stakeholders were brought into the space of children deliberately by way of our law, so that when you're handling a child custody case, for instance, there are many players. You have the court, you have the children officer, and then now you have the counselors. So that as I am sitting here and I'm handling a children's custody case, I can easily make a reference that before I even handle this issue, please go and see the counselor there. Please go and see the children officer there. Now, for family court, I think now it's a proposal for reform that we need to consider going forward.
Right.
Yeah. And I think also maybe to chime in on that, because just to emphasize the importance of including the psychosocial counselors.
Yes.
We also deal with matters to do with protection against domestic violence. And in some of those orders that we are required or we have discretion to give to protect members in a domestic setup is counseling. So I agree with you entirely that we ought to consider bringing them on board too. Yes.
I'm going to add one more before I let Aseto ask the question.
Yes, please do.
The psychosocial counselors are also needed for the officers of the court. You cannot sit and listen to these traumatic things day in, day out without it affecting you. It will affect you, whether you like it or not.
Yeah.
Right.
I agree with City. Now, we talk about access to justice, and accessing judiciary for a very long time has been seen as though it is a room for the judge, the orderlies, the security officer, and it has made Kenyans stay away from the courts pretty much. But here we're talking about a court that is seemingly changing and is friendly, is encouraging Kenyans to come and seek assistance from the court. That it's not only even at a point where, fine, come, let's dissolve this and go, but even going forward to assist where necessary through ADR, which begs the question, therefore, what has forced the court to look at it from this angle as opposed to how business has been done before? Because Kenyans have stayed away from the courts because of how the court has been painted before. What informed this change?
I think I would start from the Constitution. The Constitution that we currently have has changed the way we do, let me say, business in this country. It's quite transformative. And so the court could not maintain the same position that it has traditionally always maintained, totally removed from the people that they serve. If you look at even where we acquire the authority to administer justice, it's from the people of Kenya, under Article 159. So it is donated from the people of Kenya, and you cannot be donated a power which then you exercise on your own without engaging with the donors of that power. So that is what informed this shift in the way the court has been engaging with the members of the public. So we've sort of opened up, as you rightly say, in the form of open days to get the members of the public to get to understand us beyond the wigs and the gowns we traditionally were wearing. We've also introduced the court user committees that my brother here has spoken about, where we engage with representatives from the community and other stakeholders. And we've also the realization that for us to be effective in discharging the mandate that we do, we cannot afford to be removed from the realities that the people of Kenya do. For you to give meaningful justice, you must be able to appreciate the lived realities of the people, on whom you administer justice.
Just one addition to what my sister is saying is that picking up from the post-2010 constitution is that in every organization there's a plan, there's a strategic plan. For us in judiciary, we are currently implementing a blueprint. Social transformation through access to justice. That blueprint, what it has done is that it has now made us put a human face on dispute resolution, so that you no longer perceive a magistrate or a judge to be a demigod. No. So that is what we are doing currently, and we are really, even if you just approach us in our family court, you will be surprised. The perception that is out there is not what is really happening
in there. So some of the issues that would preclude folks from coming into court is because there's a lack of understanding of what would happen, or that there is an imagined threat in their minds that, okay, my issue will not then be sorted out. And this comes about in the issues that we hear. So last year, I believe it was towards the end of the year before, we saw an interesting ruling that came out of court whereby a spouse who stays at home, right, during the duration of a marriage is a huge contributor to what they've been able to amass. And that meant that in the process of dissolution of marriage, if that came about, that the spouse would then be considered for equal share of the property. Because previously it was said that if one spouse was out working, that then they would have, they were the ones who brought the money to the table. And then they were the ones who were able to essentially purchase. And then the property essentially belonged to them. With this landmark ruling, we saw that even if a woman, for example, was at home, she contributed significantly to that family unit. And in the position of dissolution, she would then be able to claim a significant amount of that property in that. So if you don't have receipts or documentation, because you're assuming, we're in this together. So me keeping a receipt of something that we purchased, I'm going to toss it out the window. But in the event that this marriage is dissolved, how then do you go ahead and claim your property if you don't have receipts or you don't have proof or documentation? How do you do that?
Let me answer it this way. You see, what happened is that, and let me explain it by a procedure, is that what happens is that people come for divorce. That is the first port of call. So once a marriage is dissolved, then now the main issue arises. You file a separate case for a division of property, which you may have acquired over time. What happens is that, you see, there's that ruling. What that ruling did is just to breathe life to a legislation, which was passed in 2013. That is a Matrimonial Property Act. So what happens is that before 2013, the act or the law which the courts were using to divide property and the jurisprudence which had developed before then was the 1887 Married Women's Property Act,
where even the woman was property.
Exactly.
Yes.
And that what happened then is that the law, how the law developed then was that upon dissolution, it is 50-50. Now come to 2010 Constitution and Article 45, which says parties have equal rights at the time of marriage, during, and upon dissolution. And then the same Constitution, Article 40, property rights. So what the court did in that ruling is that then was a paradigm shift from the just mechanical application of the law, that of the previous jurisprudence, that upon dissolution 50-50. And the court was really minded of the fact that over time, as it has been the tradition, is that it was deemed that it's only the man who would acquire property.
Yes.
But over time, it is increasingly became a reality that even women acquire property. So what the court did is that it did not say that you will not get anything upon dissolution. The court said that then we would then need to put this on a scale and see what mode of contribution you made. And the act, the Matrimonial Property Act, sets out clear that if you don't have receipts, how then did you contribute?
Exactly.
And it's in the law.
Yes.
Doing domestic work, child support, farm work, all those things. So those things are there. So what the court did is just to apply something called the principle of equity.
Okay, so I don't have a receipt, and I know I bought this thing. I bought this piece of land. I know I did through my work, whatever. And maybe I was working, and then now I'm at home for the last 10 years. But I know I bought this. I contributed. I didn't expect at the time that this thing was going to end. So what you're saying, essentially, that it is weighed against then maybe what I did over 10 years? And then you say, okay, actually, yes, this piece of land can go to you.
What the court did is say that if in a case where there are no receipts, then we fall back to the rules of evidence. And that is where now the provisions of you hear Section 107, 109 of the Evidence Act. You prove by way of addressing court on oath that this is what I did. And taking into account the peculiar facts and circumstances of the case, I can assure you the court will not just say you did not contribute.
Okay. I want to go to, and I know our time is running out, but one of the things that you mentioned, which we've not been able to touch on, which is a big issue, is that of domestic violence that occurs. Now, usually when you bring cases of domestic violence, even to the police, they try to remove you from a volatile situation. And you would have the evidence on you, essentially, man or woman, because we know that the cases of violence against men are on the increase. We know this. Now, what would the court be doing in this case? Saying that stop it, because a violent person is a violent person. Are we essentially saying stop it, or are you now saying in this case remove this individual from this potentially violent situation permanently? How does the court come in here? Because it would appear to most people that we need to go to the police, and then I remove myself from that situation so that I don't turn up dead one day. So where does the court come in with domestic violence cases?
Okay, the court, the court has wide-reaching powers when it comes to protection of people in a domestic setup against domestic violence. And maybe to start off, it is not that when one is exposed to such a situation, the only way to pursue this is through the criminal trial process or the criminal process, reporting to the police and expect the police to take action. Both can still move parallel. Under the the Protection Against Domestic Violence Act, a party can approach the court and make an application, seek orders to protect them. And as you rightly say, protection the orders to protect can come in very many ways. It can be just the order that desist from doing this, or if even in a case of a threat, do not do what you're threatening to do. The orders can come in the form of you need to move out of the premises that you share with, because we're talking about a domestic setup, the premises that you share with the victim or the applicant who has come before the court. It can be because you also have protection against economic abuse. Pay for this, allow them to access this. So the orders are varied. And what I would want to say here also, for the benefit especially of those that are watching us, which maybe some people may not be aware of, is that if a victim of domestic violence is unable for one reason or another to approach the court, some other person acting as a representative of that person can also still approach the court on behalf of that person to secure protection. A police officer to whom a case of domestic violence has been reported, even as he investigates the criminal angle, has that obligation or responsibility to sensitize the victim about their rights and the fact that they can approach the court for protection. Yes.
Maybe just to add on this, that why protection by the court? I think that's the question. The question, the issue is that you see, ideally, when there's a threat of a criminal act, you go to police.
Yes.
But did that work? Has that been working? I think so. So that what really implored Parliament to come up with this act, it was the realization that at times the other systems or organs of state may go slowly.
Right.
So that what it does is that when you allow the court, because the orders which the court gives is protect. When you allow the court will supervise, even including supervision of police in terms of enforcing protection orders.
Okay. Well, I mean, there's a lot, isn't there? But to have this conversation around how access to justice is actually enhanced by the courts is very important, and thank you for that. Folks are asking about the open day tomorrow from the family court. We know this will take place at the Milimani Law Court tomorrow, so it's an opportunity for folks to come in and ask. And they've asked for, in the future, think about televising such, because not everybody will then be able to make it for the open day. So that's just another suggestion that maybe the judiciary wants to think about, because people have interest, they want to know, make it a little bit wider. So thank you very much for joining us on our Justice Thursday conversation this morning. It's been with Honorable Evelyn Olwande and Honorable Festus Terere. Thank you for joining us today. Asante sana.
Thank you so much.
Good morning. It's 8 a.m.
Every now and then, fake news might